On 12th July 2019, the International Center for Settlement of Investment Disputes, otherwise known as Icsid, ordered the government of Pakistan to pay $5.9 billion in damages to Tethian Copper Company over the denial of a mining lease for a project in Balochistan. This was the largest fine ever levied against Pakistan by an international court and the second largest fine in Icsid's history. So, how did Pakistan end up with a fine as large as its most recent IMF program? Soch explains the Reko Diq case. Named after a mountain in the remote Jagai hills of district Jagai and wedged within 100 miles of Pakistan's western borders with both Iran and Afghanistan, the story of Reko Diq begins in 1993 when the Balochistan Development Authority signed an agreement with the American-based mining firm BHP Minerals. Known as the Jagai Hills Joint Venture Agreement, or CHEJVA, its key features were a 75% stake for BHP in the venture, with 25% held by BDA, exclusive rights to certain areas for mineral exploration, and assurances from the provincial government on receiving a mining lease after the submission of its feasibility study. Notably, the joint venture agreement was approved by a caretaker government between elections and without any competitive bidding. But despite that, there was initially little fuss created over the agreement. And in the year 2000, the provincial government even added an addendum to the CHEJVA, through which it clarified BDA's role in the agreement as an agent of the government of Balochistan. In the same year, BHP, which had not made any substantial progress in the project, sold its stake in the Reko Diq mine to an Australian firm, Minco, which in turn sold it onwards in 2006. And so by 2006, Reko Diq was being run by an Australian incorporated firm, Tethian Copper Company, TCC, owned in turn by British mining company Antofagasta and Canadian mining company Barrick Gold, with a 50% stake each. Simple, right? The new owners then signed an updated, slightly modified version of the CHEJVA with the government of Balochistan in 2006. For about 13 years since the signing of the initial agreement, the Reko Diq project remained legally in the clear. Until 2006, when a former MNA of the Jamaat-e-Islami, Maulana Abdul Haq Baloch, filed a petition claiming that the entire agreement was illegal and corrupt, and hence should be annulled. While the Balochistan High Court dismissed the petition, it did lead to the CHEJVA being placed on the record for the first time, having previously only been seen by a few bureaucrats in the federal and provincial governments. The allegations, combined with the long passage of time with little progress on the ground, as well as the ownership of the project changing hands several times, resulted in public perception turning against the project. And by the time the appeal against the decision made it to the Supreme Court, there was a growing media narrative that the deal had been signed in a corrupt manner that deliberately undervalued the size of the mineral reserves at Reko Diq. And so, by 2010, when TCC submitted its feasibility study along with an application for a mining license, the government of Balochistan renounced its earlier support for the project, and in November 2011 rejected the application. Around the same time, the federal government, with the support of the Balochistan government, set up its own Reko Diq mining committee, chaired by Dr. Samar Mubarakband, a prominent nuclear scientist who had given testimony in court that the mines at Reko Diq were worth hundreds of billions of dollars and could easily be extracted with his expertise. On 7th January 2013, the Supreme Court, headed by Chief Justice Chaudhry Iftikhar, announced its verdict, ruling against TCC and annulling the 20-year-old CHEJVA on the basis of corruption and violation of mining rules in the signing of the initial agreement in 1993. But amid the celebrations over the court verdict, the petitioners overlooked one key detail. The Supreme Court of Pakistan did not have the authority to be the final decision maker in this case. As per Section 15.4.1 of the CHEJVA, that authority lay with the International Center for the Settlement of Investment Disputes, or Icsid. So while the Supreme Court case was still ongoing, and a mere 13 days after the government of Balochistan rejected its mining lease, TCC went ahead and filed for damages at Icsid. 6 years later, Icsid ruled in favor of TCC. And 2 years after that, it determined that Pakistan owed TCC $5.9 billion in damages. In its ruling, Icsid acknowledged some of the allegations of corruption in the case, but ultimately decided that they were not solid and persuasive, and a higher standard had to be met under international law. Instead, it held that it was the government of Balochistan that had not met the legitimate expectations required in the agreement by rejecting TCC's mining lease application. It concluded that the real motive for the denial was the fact that the GOB had decided to develop and implement its own mining project with Dr. Samar Mubarakmand. And what happened to Dr. Mubarakmand's initiative? After spending 1.6 billion rupees and achieving virtually nothing, the project shut down in 2015. Dr. Mubarakmand now faces NAB charges in a separate Thar coal project, where he made similarly tall claims but was unable to deliver. But while Icsid's ruling may have illustrated the corruption and incompetence that has often plagued Pakistan's institutions, Icsid itself is not without its controversies. Watch part 2 of our explainer, where we examine how a network of international courts help powerful multinational corporations get away with questionable practices in the developing world.